Good afternoon. Everyone has entered the webinar as a mute attendee, but Zoom webinar has a Q&A tab where you can ask any questions during the program. We'll collect them all and answer either live during the webinar or afterward by email. And now, after a brief introduction, we'll proceed with today's webinar. As always, co-sponsored by the University of Florida Levin College of Law, Institute for Dispute Resolution. Mike?
Good afternoon, everybody.
Good
So
afternoon, everybody.
my name is Scott Schomber, and I'm here with Michael Weiss. And welcome to our webinar, Mastering Mediation, Strategies for Successful Outcomes. And we're going to be focusing on strategies for mediation before the mediation, during the mediation, and after the mediation. A little bit about me. I've been practicing law for about 33 years before I became a full-time mediator. I've been doing that for about now 3 years. During my practice, I started out doing plaintiffs work exclusively. I did that for about half of my career. Then I switched hats, became a defense attorney. I did defense work for in-house in a major insurance company here in Florida. And then I did in-house work for a major developer. And then I just did defense work, pure defense work. And so I think I've had a lot of exposure to different things, but today I'm going to be focusing on how the defense sees mediation and mediation prep. Mike?
All right. Good afternoon, folks. My name is Mike Weiss. I spent the first 12 years of my career doing defense work and then 20 years representing plaintiffs. So what you get with Scott and I, which distinguishes us from a lot of other mediators, is balanced experience. We both litigated and tried cases on both sides. We're familiar with the concerns, the issues, and the risks on both sides of the case. And I think we're both uniquely qualified and experienced to speak to and effectively communicate with both sides of the case. So if we could go to the next slide, please. We put together this presentation, as Scott said, to hopefully give you all some strategies to develop good outcomes when it comes to settlement, starting right at the beginning of the case all the way through up to and after mediation. That's the hope here. We're going to do it sort of as a point counterpoint. I'm going to present plaintiffs' issues, and Scott's going to do the same thing on the defense side. If we go to the next slide. Okay. And this kind of goes for both sides, but if you're a plaintiff's attorney, you got to treat every single case like you're going to trial. And that starts at the beginning. You have to treat your case like it's going to trial, like you're playing poker and you're holding pocket aces. You have a strong hand and you want to relay the message that you're ready, willing, and able to try the case. And it sends an important message to the other side, and it really helps get the case going. When you're a plaintiff, it's very important that you have a game plan even before you file the lawsuit. You have to have a game plan. You have to develop themes and figure out what evidence you need to prove your case. If it's the distracted driver or the corporate defendant, which is more concerned about profits than safety, those are things you need to think about before you file your lawsuit, before you draft your discovery. You got to locate your key witnesses, get statements if you can before the case, and use your discovery to shape the case for future negotiations. And finally, the only other thing I want to add, and this is sort of a pro tip, I think it's very helpful at the beginning of the case. You find out who your opposing counsel is, pick up the phone, call them. Hey, it's nice to meet you. I've heard good things about you. I had a case with your partner, whatever the case may be. Start establishing a good professional working relationship. There's a lot of reasons to do that, and we will talk about that as we go. But I'm gonna, Scott, next slide.
Yeah, and from a defense standpoint, it's pretty much the same thing. I think you really have to approach it and hit the ground running with the idea that you're going to go to trial. And from a defense perspective, I think one of the key things that I have to do as a defense lawyer is immediately start managing the expectations of my client, the decision maker, the person who's going to be ultimately attending the mediation. And to me by an adjuster. And, oftentimes the adjuster has a little bit of a head start, but I like to see, get, ahead of the game, start evaluating defenses, posturing defenses, looking at what venue we're in, how things may play out, the optics of the overall case, and immediately start, managing expectations. And one of the managing parts of that, and one of the things in managing expectations that I looked for was kind of tying in with what Mike said. You're going to hear this a lot from us. I don't think people do it enough where you're reaching out to the other side. And if you do this long enough, you're going to start seeing the same people on the other side from time to time. You're going to have past working relationships, and you're going to have some understandings about what they can and cannot do as far as litigating a case, preparing for trial, and actually trying a case. And these are all things that I think your client on the defense side needs to know. And also, is there an opportunity for an early mediation? I can't speak enough about the benefits of early mediations. Sometimes cases simply aren't ready to be mediated. There's just not enough known, and there's not enough, testing of the theories, both on the plaintiff side and the defense side. But there are quite a few cases that if both sides, particularly if they have a good working relationship and an idea of trying to get it done quickly, an early mediation is really a key thing to consider. There's no cost that have been incurred. The expenses are very minimal. The emotional investment is somewhat limited. And it oftentimes ends up saving a lot of money, time, and effort. And I find that, I have a subset of clients mediation clients, who routinely seek out early mediations to kind of deal with difficult cases, problematic cases right up front and on the front end. So I look at all the facts when the file comes in to kind of assess it in that way, manage my expectations of my client, and also try to see if there's an opportunity to resolve the case early on. Next slide.
Okay, so if you are a plaintiff's lawyer, typically the first 3 months of the case, you have a huge advantage because the defense attorney most likely got the file 2 days or a day before an answer is due. So, the first 3 months are critical. Use that time to get things done. Take the depositions of the parties, the depositions of key witnesses, lock in the testimony. Again, everything should be focused on how am I going to prove my case? How am I going to prove notice, dangerous condition, negligent maintenance, whatever the case may be? So you want to get those depositions done. Again, by reaching out to opposing counsel beforehand, you can tell opposing counsel, hey, this is what I think the case is about. This is what's coming your way. And, obviously the defense attorney is going to try to get evidence to disprove what you're telling them, but you have to have the game plan. I also recommend tailor the discovery, right? If it's a premises liability case, you need policies and procedures, you need maintenance records, you need employment records, other similar incidents. That's the ammunition to prove your case. So you have to have those things. It has to be in the discovery. The other thing I would say is anticipate objections and tailor your discovery. Do you really need maintenance records going back 50 years? You're likely to get an objection, and it's likely to be sustained as overbroad. So, tailor your responses. And if you don't get responses, you need to set those objections for hearing and get it heard. And you can't let those things linger. If there's things that you need for your case to develop your evidence, you got to get it. Get those responses. A lot of times there may be dispositive motions that I see the night before a mediation, somebody files a motion for summary judgment. Those things probably, they need to get filed. I know it's hard to get special sets and get them heard, but at a minimum, if there's an MSJ filed, have a response. At least that's in the court file, even if the hearing has not happened. So all of those things can be on the table when you go to mediation. Next slide.
Yeah, and again, we're kind of echoing one another, but I would disagree. I think the defense has the upper hand in the early stages. We have access to the accident site. We have access to the witnesses. We have access to all the maintenance records and all the items that plaintiff is tailoring, sitting back in their office thinking about what they asked me. I already have all that. And you know, I see good defense lawyers, and the reason this isn't just preparing your case. I see really good defense lawyers who do very well at mediations. It's very clear to me that when they were doing their initial investigation, they were not just simply doing fact finding and things of that nature. They were taking videos, taking photos of accident sites that most likely were going to change by the time it got to mediation. And they were doing it to preserve it and make videos and demonstrative evidence that could be used at trial, but also during the openings in the mediation. You know, we've all heard the saying, picture's worth 1,000 words. Well, I would say a picture's worth 1,000 words, a video is worth 1,000,000. And if you, as the defense lawyer and the person who has access to all this information, the ability to lock that down, prepare it, and get it ready for an exhibit for both trial and mediation really helps out. I also have done a lot of work for a large carrier, or not a carrier, but you know, a public transport carrier who really, when they had accidents, nailed down how to prepare for, you know, do the fact finding. And they would arm me with the best videos, the best statements, the best evidence that was presentable not only at trial, but at mediation. And one of the things that was done from a defense standpoint was not only getting the CCTV footage of the area and things of that nature, but also surveillance on the plaintiff very, very early on before the plaintiff and the plaintiff's lawyers even thinking about any of that. All that is great cannon fodder for openings during a mediation. And so I really encourage everybody, get out to the accident site, nail everything down. You have the advantage here. Plaintiff is just thinking about and just drafting their discovery. You can be there actually participating in it. Next slide.
All right, preparation for mediation. So a lot goes into this, obviously, but you know, really, number one is you have to do a realistic evaluation of the liability. You know, a lot of times in mediations, I'll ask the attorneys on both sides, you know, if you try this case 10 times, how often is it 100% plaintiff verdict? How often out of 10 times is it a defense verdict? How often out of 10 times is it a split verdict? So, you know, you really have to do a realistic evaluation of liability, consider comparative negligence. Obviously, the tort reform changes that went into effect, the 51% now. I mean, these are things that you really have to consider, you know, to evaluate your liability. Also, get a firm handle on your damages. You know, if there are medical bills and liens, you as a plaintiff's lawyer, you need to have that before you come to mediation. And I understand that if the plaintiff is still treating, you may not be up to date, but it just is a bad look when you come to mediation and you have no clue what the medical bills are, what the liens are, and things of that nature. So you have to have a handle on that. And these days you have to have a handle on how your particular judge rules on these tort reform issues as it relates to medical bills. And then once you have those things, I would suggest you have to have a firm settlement value range, okay? And you think about it, talk about your friends, colleagues, talk to your partners. What do you think? And have a range. Then, especially if you're a plaintiff's lawyer, you have to prepare the client. You have to prepare them for mediation, and that's a task, and that you have to spend some time with them. You know, we could do a whole seminar on how to prepare clients for mediation, but you know, most of the time a plaintiff's never been at mediation. And so it's important for the lawyer to, number one, prepare the client for the defense lawyer's presentation. Some defense lawyers are more gentle than others when talking about the issues in the case, but they have to understand. They have to understand the initial offers will probably be pretty low. They have to have patience. They can't show emotion, and they really have to focus on the outcome. You know, and then most importantly, before you get to mediation, plaintiff lawyers, you got to get a commitment from your client that they're on board with your settlement value range. In multi-defendant cases, You need to figure out, okay, is this a case where we must have a global settlement, or can we settle with folks individually? That is important. Another thing, I think both Scott and I would agree, prepare the mediator. We are more than happy to review summaries. It doesn't have to be a treatise or the Constitution or the Magna Carta, but a focused mediation summary highlighting the really critical facts and issues, the leverage points, and the obstacles and practical concerns. That's really helpful it doesn't have to be anything fancy. It could even be a phone call to the mediators, but I would strongly recommend that. Next slide.
Yeah, and it's similar takeaway from the defense. One of the advantages of doing defense work is frequently you have sophisticated clients, adjusters who do this day in and day out. They know the value of the case. They understand the issues. They understand tort reform. They understand, comparative fault and things of that nature. But there are occasions, particularly under today's, in risk management schemes and structures of insurance, where you will have not only, insurance adjusters there, but there will be significant SIRs, there will be self-insured folks, there will be people who have large policies who have a lot of sway with the carrier, and they meaning the insured or this person that has the self-insured retention, they're the ones making the initial decisions. And it is so important to figure out who has the initial authority, who's going to be opening up and having the discussions, and participating in this negotiation with you. And if there is a SIR situation where there's a significant self-insured portion, but the value of the case goes into actual insurance money, there needs to be an understanding as to how that dynamic's going to play out. Is there going to be an immediate tender to the SIR to the carrier, or is the carrier expecting it to be done within the SIR amount? And who's going to be calling the authority? I cannot stress how often in that dynamic there is time spent in the mediation figuring that out, where I think the better strategy is before the mediation for the defense lawyer to get the adjuster on the phone, talk about the case, talk about the strategy, what the goals are. Are we going to be flexible on our goals, what we see the case being worth? Also have the insured on board if applicable. Like I said, if there's a self-insured retention, you're going to have an insured or an insured rep there. Are they in agreement with how the carrier's seeing it? Is there a conflict? Is there something that we can take and work out ahead of time so that this conflict isn't playing out? And particularly, you don't want to be apparent to the plaintiff, but you certainly don't want to waste time. And if you have that meeting ahead of time and you understand that there's a disconnect or that there's a disagreement as to how things can be proceed forward, the number one call should be to the mediator. As a defense attorney, you should say, hey, listen, I got to give you a heads up, Mr. Mediator. We have an issue coming into this. We have a case that's worth X. The carrier doesn't feel it's worth anywhere near it. The self-insured is, expecting the carrier to participate because they want to get rid of it, if that's the issue. Or maybe the self-insured portion doesn't want to put any money on it because they're looking at it from a position of principle as opposed to a hard, calculated risk manager or professional analysis of the risk of the case. That's when sometimes the mediator has to have a heads up about that problem in that room. I have oftentimes, when I've had lawyers tell me that that's an issue, I ask them to get everybody on the call and we have like a little pre-mediation amongst ourselves to develop a strategy and see how we can work through all that and get that ironed out. So again, you'll hear me say this over and over. I think the number one job as a defense lawyer is to advise the client of what's coming, evaluate the case, manage the expectations, and understand and manage what we're going to do at the mediation. What's our end game? Next slide. Oh, wait, and before I go on, another thing, Mike brought it up about multi-defendant cases. There's footwork that has to be done in the defense room, too. If you have 3 defendants in there, and your client's expecting the other 2 to pay, you may want to pick up the phone and call the defense lawyer for those other 2 and say, hey, what are your clients looking to do here today? And are we going to negotiate globally? Or are we going to make individual offers? Are we going to, have a united front, or are we going to be pointing fingers? A coordinated defense, not only in the presentation aspect, benefits the defense room, but also in the mediation aspect. Because I cannot tell you how many times I'll have, multi-defendants, and we spend the first hour trying to figure out how the negotiation process is going to go down. Is there going to be, global offers? And if there is global offers, I'm only contributing X percentage. You got to contribute Y. And then that whole dynamic goes back and forth for about, 40 minutes before real negotiations start happening. If we can get ahead of that, A, it makes the mediation a lot smoother, and B, gives the defense a much more united front that the plaintiff's looking at. Next slide.
Yeah, just on that point, I can't agree more with Scott on multi-defendant cases. I oftentimes spend a lot of time going back and forth between the defense rooms because they haven't talked beforehand about, okay, how's this going to go? Do we want to go percentages? Just some sort of conversation going in on how the negotiations would go. I mean, typically, the understanding the coverages is really more of a defense room issue, but plaintiffs' attorneys do need to know what the limits are, know if there's excess, understand if there is SIR, who has skin in the game, so to speak. And this way who you can direct, your comments to. The other part I would talk about coverage, and this is an oftentimes underutilized coverage by some plaintiff lawyers, always find out if there's med pay available and try to get that med pay, because it's another $5,000 or $10,000 that can be used towards the medical bills or the liens, and it could be the difference in getting the case over the top to a settlement if you could get some of that paid down, and take advantage of that coverage. So next slide.
Mike, is that yours?
This is you, Scott. I mean,
Oh, I'm sorry. Yeah, forgive me, folks. Yeah, and I'm going to echo the same thing. Understanding the amount of insurance is key. And this is, you may, when I say this, there are going to be people who are going to scratch their head, but I cannot tell you that I've had several mediations where the defense attorney doesn't really even understand the insurance and the insurance available, or he understands it less than the plaintiff's lawyer. And I think that everybody needs to understand what insurance is available, where the insurance, what I call the breaks are, meaning where the coverages begin and end. Is there self-insured retention? And if so, how much is it? And who's there participating on behalf of that? Then, the next layer of insurance, where does that begin and where does that end? And, is there any coverage defenses? Okay. And that's a key thing. I think, a lot of plaintiff lawyers say, well, that's a defense issue. I'm here just pushing forward with my lawsuit. Well, yeah, maybe yes, maybe no. If there's a carrier with a very strong defense, a coverage defense for their particular client, you may want to understand that coverage defense, because if you make a presentation as a plaintiff's lawyer that basically walks right into that coverage defense, guess what? That adjuster's not going to be putting up any money at the mediation. Likewise, if there's multiple defendants and one has a good coverage defense and the others don't, I think you may want to tailor your presentation to target the person that has the money. I look at it this way. There's a pie of money that everyone's trying to get a slice of in a mediation. You need to understand how big the pie is, and you need to understand whether or not all the slices are available. And if you don't, you really are operating in the dark. And plaintiffs, I feel you can really see the ones that understand the coverage better, because they are consistently working each layer against the other as they're moving through the tower of insurance. So, it's one of those things that, understanding coverage, both from the defense standpoint and from the plaintiff standpoint, is key. The other thing, and I go back to this whole thing about, managing your clients, particularly when there's multiple layers of insurance. And this is particularly true if the layers of insurance are with different companies. It's like herding cats at mediation if you guys don't have a strategy. Get the strategy done about how the coverage is going to be dealt with at the mediation, who's going to be the primary speaker, who's going to start off. Is that person going to tender it? Is that person is the what layer is going to be the one leading negotiations, and who's going to be the one calling the shots? Finding that out at mediation is a disaster. Oftentimes, I will hear, from one layer of insurance that's north of the primary say, well, we had no idea that we were going to be even involved in this. We got this letter the day before and we're here. That's clearly the fact that they got a letter and nothing further. They're unprepared, and it really, there's many mediations as a mediator. I love it, but I want the mediations to be effective. And this is one of the key things that you really need to understand in order to go forward. Next slide.
All right, let's talk about during the mediation. Deliver a concise, organized presentation directed to the decision maker, not necessarily the mediator or the other attorney, but to the decision maker on the other side. And folks who have done mediations with me know I often talk about psychology. Right. As a lawyer, I was so wrapped up in advocacy for my cases, I never really thought about the psychology of mediation. But now I do, obviously, as a mediator. You obviously want to convey the appearance that you're ready, willing, and able to go to trial. You're ready, willing, and able to spend the money, do the work, whatever it takes. But really, if you're directing your presentation towards the decision maker and think about the psychology in the other room, you want to be able to give them clear reasons why they can justify paying what you want them to pay. They're going to have to go back to their bosses and explain, hey, why did you settle this case? Or why are you recommending a settlement value, of a certain range? So, you have to give them clear reasons to justify that payment. Oftentimes, things could get hot during a mediation. I always suggest try to keep it professional. And there's gentle ways to highlight the risks or problems with the other side's cases. It happened, like, for example, one side is talking about filing a motion for summary judgment, but it's too late. The expert disclosure deadline or expired proposal for settlements and things like that. You have this stick, but you don't necessarily have to beat the other side over the head with it, or certainly you don't want to point out, the other lawyer's inadequacies or insufficiencies. That's not going to get you anywhere. So, you can do those things, try to do it gently. Those are some things I would think about. Obviously, negotiate with confidence. Okay. Not every single case needs to be a policy limits demand, and not every single case the first offer needs to be a very nominal first offer. So, have a little confidence, be patient. And I understand, obviously, if you're a plaintiff, you want to start out high, you're a defendant, you want to start out low, but you don't have to necessarily go to the policy limits demand every single time or the $2,500 initial offer. And as you go through the case, as you go through the negotiation, yes, you want to be patient, you want to be disciplined, but you also want to be realistic with your numbers, because again, you're trying to come to something where the other side has to think hard about what you're offering or what you're demanding. So, next slide.
And one of the things that I see unfold all the time, and years and years ago, an old mediator said to me, this is going to date how long I've been doing this. He would sit back and he'd smoke a pipe. This was back when you could smoke inside offices. And he would look at me and he goes, Scott, don't agitate, negotiate. And it is so true. When you come into, and I see it on both sides, I see it on the defense side, where some defense lawyers will come in and they have, a 300-man firm, and they have all the power of all the insurance companies behind it. And they come in, they start off by telling the plaintiff, A, you're a fraud, B, we're going to bury you, and C, we're a 300-man firm and we're the big elephant and you don't stand a chance. And it's just a down and outright attack. And as this is happening, I can see the plaintiffs, arms getting crossed, becoming defensive, retreating from not even wanting to be there, his lawyer becoming the same way. And it does nothing but agitate them. Okay. And, I look at mediation as a time where we're all trying to work towards a common goal. Trial is when that's going to occur. Trial is when the attacks are going to occur, and trials are going to be where you're going to try to score points. And mediation, I think you want to disarm the plaintiff to some degree. I see a lot of smart defense lawyers acknowledge the incident, acknowledge that there was an injury. They don't acknowledge fault or anything of that nature, but there's a lot to be said about acknowledging that we're here. We're here to try to get it done. We have some disagreements. I'm going to talk to you about this, but first I want to say that we're sorry this happened to you. This is not what my client wants to have happen on his premises or under his care, things of that nature. These are things that you can, when that's being said, you can actually see the plaintiff starting to listen. When they become defensive, they're not hearing anything you say or any reason why they should come what we want to do. And the same thing happens sometimes, and Mike touched on a little bit. There will be times where a plaintiff's lawyer will attack the defense lawyer for not getting something filed timely or something of that nature. Defense lawyer immediately becomes defensive. And guess what else happens? His client starts to look at him and say, why are you my defense lawyer? And why am I listening to you during this mediation? That's something you don't want to have happen during a mediation. You want to have the adjuster having confidence in his attorney, because when his attorney is recommending, yes, we should settle this, you want that adjuster to be having confidence in the defense lawyer. So I really find that the most effective mediation openings are the ones where they're not attacking either side. They're rather trying to, acknowledge that we're here to try to reach an agreement. And here's why I see things this way. And I put them as, I kind of describe it as that there is like little nuggets that the defense lawyer is giving me in a very non-confrontational manner that I can use during the mediation process, during caucus. Like, for example, they might bring up the fact that, there was an open and obvious thing without really beating the plaintiff over the head with it, but tell me why it's open and obvious. And me as a mediator, when we go into caucus, can circle back around and touch on each one of those nuggets ahead of time and see whether or not, they're going to make some headway in the plaintiff's room. The other thing that I really recommend, it's going back to that idea of giving the mediators nuggets to work with. Sometimes openings can't be all that, non-confrontational, or maybe there's a reason that the parties don't want to do openings. I get that from time to time. If that's the case, getting me, the mediator, a pre-mediation summary, whether you're the plaintiff or the defendant, is really key, because I will use that summary to look for those nuggets when I go into the plaintiff's room and go, well, what do you think about the tort reform and how this is going to influence your bills? The defense tells me they have an expert that says it's going to be X. How do you respond? And get them thinking about that. And if plaintiff does the same thing, I will bring the plaintiff's nuggets in their opening statement into the defense room. Giving the mediator the tools to talk during caucus is really key and something that should be done, again, in a non-confrontational manner. Next slide.
Yeah, just to kind of really highlight this, because this happens pretty often, and again, I go back to psychology, right? You want to make sure that both you and your client, you don't get angry. You don't allow your client to get angry. And how do you best do that? Well, first of all, like Scott said, avoiding the personal attacks. If you're a defense attorney and you want to settle the case and you want the plaintiff in a frame of mind to be reasonable and to listen and to understand the risks and all that, how better to get them in a good frame of mind by doing the things that Scott was talking about. A lot of good defense lawyers do. When you attack the plaintiff, call him or her a liar, a cheat, or whatever, attack the plaintiff's lawyer, it's doesn't get people in the frame of mind to be reasonable. Similarly, it goes the other way. You're not going to get very far if you are a plaintiff's lawyer and you're going after the defense lawyer and telling their client or corporate rep or adjuster what a poor job the defense attorney's doing. You're not, and you ain't going to make any friends either. The righteous indignation that comes at trial, but not the right place at mediation. Personal attacks are, often counterproductive. Again, going back to psychology, understand and anticipate the other side comes to mediation with their own settlement range. Okay. And your job as a plaintiff's lawyer is to try to see if you could get them to that settlement range and try to push to see if they'll go slightly higher. Defense, it's the same thing except the other way. You are playing chess. It's not checkers. It's not tit for tat. Often we see that at mediations. You're thinking 3, 4, 5 moves ahead. I touched on this earlier. Don't make initial offers or demands that are ridiculously high or low. I understand you need to leave room for negotiation, but if you make an opening demand or offer that's not even in the ballpark of what's reasonable at your very best day at trial, then you're setting the stage for failure at mediation. And your opponent's going to react with the same type of ridiculous offer or demand. So credibility is important at mediation, just like it is at trial. Most experienced attorneys know that asking the jury in a closing argument for a award number that's ridiculously high or ridiculously low based upon the facts, that affects your credibility. And it's the same thing at mediation. And finally, back on negotiation, make moves to encourage the other side to get to their ranges, to their settlement value ranges, right? A lot of times, I've used this analogy many times in mediation, that negotiation is a bit like fishing. If your bait is a mile away from the fish, you ain't ever going to catch that fish, but you drop that bait down a little lower and the fish could see it and smell it, they'll sometimes come up and hit it. And so, I think as you go through the negotiation, I would suggest think about the fishing analogy. Next slide.
Yeah, and yeah, I'm going to echo that. This whole dynamic that occurs in almost, I would say probably 70% of the mediations I do, where the plaintiff comes in and gives an opening demand that's clearly, 10 times the value of the case. And then the defense comes in and gives a opening offer that's worth 1/10 of the value of the case. And this goes on back and forth. And, look, I think that everyone on this call, when they go to mediation, if it knows what they think the value of their case is. If they don't come in there, then they're just spitballing it. And I don't think anyone on this call is doing that. We know what we think the case is worth, and both from the plaintiff's perspective and the defense perspective. And they rarely overlap, okay? But they oftentimes are in what that same mediator that I told you about earlier said to me. There's a zone of relevance. There are numbers that, from the plaintiff's perspective, even the defense lawyer can go, yeah, I can see that value there. And from the defense perspective, even the plaintiff's lawyer could say, yeah, I could see the case being down that low too, in that range. That's the range where the real work gets done. And, to start off with these, artificially high demands and artificially low offers does nothing again but agitate everybody. When the plaintiff comes in on a $50,000 case and demands $1 million, all that does is agitate the adjuster and the defense lawyer, and then they give a $500 offer, and all that does is agitate the plaintiff. And here we are trying to get past this matter of agitation. I really recommend that the parties try to find a way, even if they start off high, to quickly move towards the number that they want to go. And what I kind of look at is, again, you come into a mediation, or you should know the area that you want to end up at. You can start up high, but I would suggest that in the negotiations, you move quickly through the gap between where you start and where you want to be. The first 2/3 of that quickly, the last third is where the real negotiations start. And if you move through the first 2/3 of that gap quickly, defense will see that and they will probably respond quickly. Then you will get to your last third and the defense's last third, that's the zone of relevance. That's where the value of the case truly is. And that's where the real hard work gets done. The faster you can get to that, the better. I give this example all the time. I mediate with a particular lawyer who does this every single time, and it works almost every time. He comes in, gives a high number. The second round, he creates a bracket and moves drastically through midpoints down to where he wants to be. And the defense sees this, and they respond in brackets, and they move up quickly. The mediation moves very quickly. The gaps get closed very quickly. And then this particular plaintiff's lawyer, his strategy is he just goes, all right, here's my number, pay it. The defense is caught a little off guard. Quite frankly, they move more faster than they wanted to. And now they're faced with paying a gap of another 100,000, another 50, and the plaintiff is just leaving. 90% of the time, defense reaches in, makes a call, closes that gap. And I would say that the value of moving quickly created a kind of wave of optimism in the defense room that the defense and the defense lawyer and the adjuster rode to the point where plaintiff said, okay, I'm done coming down. You now got to close it and settle it for me. And he's very effective at that. And it's because he moves quickly through these, the gap of where he starts to where he truly wants to be. And 90% of the time, it works for him, And then the times that it doesn't, about a week later, the defense gives a call and says, yeah, I got the extra money. Can we do something here? It's very effective. And I would really encourage people to try to not engage in that initial agitation that is created by the artificially high demands and artificially low offers. I'm going to make one other thing too, and this may or may not be known by everybody. One of the challenges that the defense room has, and a lot of plaintiff lawyers don't know this, is that an adjuster or a defense lawyer, if they're in-house or even if they're not in-house, oftentimes will have their files audited and see how they are responding to demands being made during mediations. And if an adjuster is seen as moving too quickly, that could be a problem for him professionally. Sometimes plaintiff lawyers can't understand, well, I'm moving, but he's not moving at all. You got to recognize there is sometimes things behind the scenes that are pressure that are on the people in the other room that aren't really here at the mediation, but they are there in their life. And so I would encourage sometimes, I love brackets because I feel that brackets allow signals to be sent. And if a plaintiff sends a good signal and the defense doesn't respond, you can always retreat from the bracket and go back up to a hard number to kind of show the defense, hey, I was willing to come in and engage. You didn't engage. Please engage and I'll come back again. So these are things that I really, I really try to encourage. It's not necessarily the best business model as a mediator. The longer that we spend, with artificially high demands and artificially low offers, that only inures to the benefit of the mediator. Honestly, if you can get to that zone of relevance quickly, that's going to, make the mediation go a lot faster. People won't be agitated. And again, that's where the real work begins. Next slide.
Yeah, and just to sort of put a further emphasis on what Scott was saying about getting to that zone of relevancy, I have found as a mediator, there's a higher likelihood of a case settling when the first few moves are significant moves, when the moves are designed to create momentum and to influence the psychology of the other in the other room, right? You want to make moves to encourage the other folks, to give the appearance, hey, we're being reasonable, we're trying to get this done, and look, not every case settles, but I think cases where we have good movement, the first few moves, those have a higher tendency to get resolved at mediation. Now, how to use the mediator strategically. In the old days when Scott and I both had a lot of dark hair and we did mediations in person, you can pull the mediator into a private room and have a private conversation. These days with everything on Zoom, what I typically suggest to the attorneys, if I can speak to them before the mediation starts, you have my cell phone number. Text me. If you are having an issue with a client or something, text me privately. And then I can come into the room and sort of organically address some of those issues. That is a very effective way for me and Scott, the mediators, to give you more credibility when we sort of parrot the same things you're telling your client. Hey, there's problems with the case. Then the mediator comes in and talks about, well, we got comparative negligence or, whatever the case may be. So that is a pro tip. If, reach out to the mediator either beforehand or during the course of the mediation, text the mediator, hey, I'm having a client issue. Other ways to use the mediator strategically is sending messages to the other side. Ask the mediator questions about the vibe in the other room, and to the extent, things aren't, privileged, if there are things we could tell you, we can tell you. I certainly invite folks, obviously it's your case, your mediation, you are the decision maker along with the client, but if you want my opinion, I'm happy to give it to you. What do you think, Mike? What should we do about this? Scott, what do you think? We're thinking about doing this. What do you think? Use the mediator. I think that's a great a great source of information that not a lot of other people, not all people use. And finally, sometimes if things are sort of coming off the rails out of mediation and it doesn't look like we're making progress, sometimes it's very helpful just to bring the lawyers in a private room together with the mediators. Hey, let's talk. What do you need to get this case done? What can I do to get us across the goal line? And again, this goes back to the very beginning. If you have a good working relationship with opposing counsel, then you can have that kind of conversation. Hey, we're 50 grand apart. What can we do to get to where we need to be? So I think that's a good tool to speak privately with the other lawyer. So next slide.
Yeah, and another thing too, there's a couple things. Number one, we talked about how sometimes, and look, it happens. I would be lying to you if I were to say that every case I mediated as a lawyer, I was 100% prepared and I had all my I's dotted and all my T's crossed. The reality is that's not possible all the time. Okay. And there are times where you may not have, as a defense lawyer, all the lean information or all the updated information and things of that nature. If that happens, by all means, we're all here. We're all here at the meeting. Have the mediator go over and say, Scott, Scott, I need the records from the last two visits that they mentioned in their opening, the last two doctor's visits, have me go over there and get them. Have me go over there and get the lean information. If you're a plaintiff's lawyer and you want to understand what the defense is saying about, he has an expert that says that your medicals aren't 200,000, but literally, $45,000. Ask me to go over there and get them. And if the defense is going to share them at the time of the mediation is there. I sometimes describe myself. I say it all the time. Use me as a de facto discovery tool. If there's more information that you need, that'll help you better evaluate this case today here during the mediation. And a lot of people take me up on that. The other thing too is like, remember, I'm the only guy as a mediator who's been in both rooms. And if I'm kind of saying certain things, I really think, it's incumbent upon the people to kind of listen because, I'm trying to say things with the intent of giving some guidance or to give an avenue that might lead to a resolution. And again, I'm the only guy that's been in both rooms. If there's a problem that I see developing in the other room, I may, with the permission of that party, kind of convey it to the other side so we can figure out how we can address it and how we can overcome certain things. And Mike brought up something that probably doesn't get used enough in today's world. The idea of at the end of the mediation, when everything is kind of, you're at your wit's end, bringing the lawyers into the room and just kind of, seeing if there's a way to hash it out. Oftentimes it gets done right there when the lawyers have an idea and they go, look, if you tell me X, I'll go see if I can go get X for you. And that ends the mediation, or at least there's a candid conversation that after the mediation, things can be addressed further by either getting additional authority, having the defense lawyer write up the file so that they can summarize what happened at mediation, and here's what may have been impossible as far as a settlement route. and that might lead to further discussions post-mediation. Next slide.
All right, considerations for impasse. Sometimes it can be strategic, right? Sometimes, especially, well, from both sides, really, you want to show the other side that you are willing to walk if we don't get to a certain number. And having an impasse can sometimes help sort of get the case closer to the finish line, whether there's additional conversations that need to be had to reduce the demand because there's medical bills that we need to talk about reducing, or on the other side, the claims rep needs to go to a supervisor. Hey, there was a few things we didn't consider. Maybe we need to put a little more money on this to get across the finish line. So impasse, is not always a bad thing. I would suggest, and I know Scott and I are both the kind of mediators, we're happy to stay involved. Sometimes the lawyers get along great, and after mediation, they continue talking and get a case resolved. And I love to hear when that happens. Sometimes, because whatever, personalities, this and that, it's helpful for the mediator to stay involved. And we're both happy to do that. But again, this goes back to, if you have that good working relationship with opposing counsel, you don't need the mediator. It's not the end of the world if you do. We're both happy to stay involved and try to help, because we know from our, selfishly from a mediator perspective, that's what makes people happy, right? Lawyers, clients happy. We get a case settled, everybody's usually happy. And then another thing I like to do before we end the session, if it's not going to settle, get a vibe. Is there any possibility of more movement after the fact? So the parties at least leave the mediation with a sense, hey, maybe something could happen, if X, Y, and Z happens. So, sometimes an impasse is okay. You have to do some further discovery, or get a deposition done, or records and so forth. So it's not the end of the world to impasse, I guess, is the point here. Next slide.
Yeah, no, and look, I'll echo that. I think, someone once said to me once that the power of no is one of the strongest powers you can have. It's just saying, nope, that's not going to work for me, and getting up and walking out. It sends all sorts of signals. Most of the times, it makes people sit up and say, okay, well, that's we made a shot. We're going to have to go back and get more money. Or if you're a plaintiff, we may have to kind of, reconsider where we're at. So I'm a big believer that, the word no should be used from time to time, and it is a very powerful word. That all being said, if you're going to say no, and you're going to impasse, I really do think it is helpful if the plaintiff signals what their bottom dollar may be and the defense signals what their top dollar may be. And you don't necessarily have to come forth and say, well, my bottom dollar is 100,000. If you want to say that, that's great. Or if you don't want to say it, you don't feel comfortable because you're fearful if my bottom dollar is truly 100 and I come in and say 100, the defense is going to try to knock me down to 75. That's a valid concern. You can address that by simply going, I'm going to leave you here today. I don't think we're going to get it done. I see this case being between 125 and 75,000, or something like that. Something that you feel comfortable arming the mediator with, to go into the defense room and say, listen, they're sending a pretty clear signal where they need to be. And let's talk about that range. Is that something that could be doable? And things, is it something that, you might do worse at trial and things of that nature? Same dynamic in the defense for the defense. The defense, in my mind, should oftentimes signal to the plaintiff what could happen or what they might be willing to go to, and whether it's formally or informally through a bracket or a range, or just kind of a suggestion to the mediator that I can kind of talk through and things like that in the other room. That does a lot of things. It allows people to see what, both from the plaintiff's perspective, what they could put in their pocket, and from the defense perspective is like what it might take to take and shut down a file of theirs. And and one thing that I didn't touch on, and again, allowing the plaintiff to see what might happen, what might be able to be put in their pocket. That's a key thing. The plaintiff needs to understand they're not here to get their lawyer paid. They're not there to get their doctors paid. They're there to take care of all that, but also to put money in their pocket. And to the extent that there can be signals shown, if we want to settle the case, hey, here's an opportunity. This is what you could walk away with. I can then do mediator math, even with an informal suggestion, to get the plaintiffs to start thinking, maybe I do have an ability to walk away with a win here today. And maybe I'm a lot closer than I think I am, or what the negotiations has shown thus far. So I really, if you're going to do the impasse, I think there's some wisdom in defining where both sides are leaving that impasse. So you're now dealing with a smaller playing field going forward than you started off with coming into the mediation.
Scott,
Next
can I
slide.
just add one more thing on this
Yep.
this issue? Another thing to think about on the impasse is, how do you want to leave it off, right? I think it's worth considering whose court do you want to leave the ball in? Okay, the plaintiff last gave a number, the defense last gave a number, and that also is a strategic thought about okay, I gave them, they asked for a bottom line number and I gave it to them, or they asked for my
Yep.
top number and I gave it to them, and now I gave you my top number. If you want something else, then you need to make a move, plaintiff. But the idea of thinking about strategically whose court
Mm-hmm.
you leave the ball in.
And if you want to do a time limited demand or time limited offer, things like that too, those are helpful too. And that kind of ties in when none of that works and everyone's at their very wit's end. I like to suggest, and it only works in situations where we're relatively close in the mediation as far as getting the case settled, but we just can't get any closer. I oftentimes bring up the mediator's proposal. And the way I do mine, I basically send out a letter after the mediation saying, hey, I'm the mediator, I've been in both rooms. This is the number I think the case could settle for. It's not what I think the case is worth, because that's not it. It's not what I think a jury will do. It's basically what I think I can push the plaintiffs down to and what I could push the defense up to. Basically numbers that they couldn't negotiate on their own. This is really kind of, it allows a couple things to happen. If the parties agree to do that, they take my number and the plaintiff goes out and sees what the medical providers are going to be willing to do if a number like that came in. That allows them to understand with certainty what will go in the plaintiff's pocket and whether or not that's something the plaintiff will entertain. If there's an issue of having to get more authority, the mediator's proposal allows the defense to go back to who they have to, their committee and things of that nature, and run it up the flagpole and say, hey, this is what the mediator recommends. Can I get some more authority? Oftentimes, it's like a Hail Mary that helps close the gap, and it's something that's worth considering. Obviously, if there's a huge gap, meaning like, the plaintiff wants $1 million and defense is at 75,000, that's never going to work. These are for issues where we're close, but we just can't get the gap closed. All right.
And the other nice thing about the mediator's proposal, it gives both lawyers cover, right? You're on the plaintiff side. Hey, this neutral mediator heard this whole thing and he came up with this number, sounds like, and same thing on the defense side. The defense lawyer can go back to his client. Hey, I told you what I think the case is worth. And now you're hearing it from the mediator. It just gives the lawyers potentially gives the lawyers some cover. So I think that's pretty much it. Next slide.
Yeah,
please.
and I think we're running out of time. So,
well,
I
thank
don't know
you
if there's
all.
any questions.
You did great on the timing. Thank you. So we want to give the CLE number now.
I can't hear you, Kathy.
Hello? Can you hear me?
Yeah, your audio is a little bit low, but everybody could see the course.
That better?
Yes.
Yep.
Okay, here we go. If you are a Florida attorney, please jot down the Florida Bar Courts number so that you can post your CLE credit online. It is 260-754-8, N as in Nancy. That's 260-754-8, N as in Nancy. Please watch your email inbox for news about our future webinars. On September 30th, we'll feature a CLA program from our Business and Commercial Law Practice Group with mediators Matt Weissing and Charlie Green. And thanks you guys very much. Thank you, Mike, and thank you, Scott. That was great.
Thank you, everybody.
Thank you all.